Hi, good morning, and welcome back to the channel. Happy Father's Day to all the fathers that are watching the video. I'm Niladri Mukherjee. I'm a regulated Canadian immigration consultant and I practice in Windsor, Ontario, Canada. A quick background, me along with my wife, we own and operate Nuvonation Immigration Consulting. It's a boutique immigration firm. We don't have any employees. We Shreya and I are the ones that directly work with all the clients, and we predominantly specialize on working for various kinds of procedural fairness letters. And as a result, we have seen probably all the different shapes and the forms and the variations of procedural fairness letter. Now, I have hundreds of videos on the YouTube channel, but I just thought to make one quick video to let you know what a procedural fairness letter is all about, the 2025 things, anything new that we see, and anything and everything about procedural fairness letter, right? So let's just jump right onto it. To start with, what is a procedural fairness letter? Okay, so the procedural fairness letter, as the very term says, is called procedural fairness, which means that it's a letter that's been issued by Immigration, Refugees, and Citizenship Canada to maintain the fairness of the process. Now, the reason I explain that is because a lot of time people tell me that I read it on internet, that if I receive a procedural fairness letter, it's the end of the story. So no, right? The fundamental definition of a PFL is to maintain the fairness of the process. So if the officer has any concerns, it could be serious concern, it could be routine concerns, or now this is important to understand. It could also be the concerns because of which an officer must have to issue you the procedural fairness letter. Okay, so it's not that if the letter is being issued, it's all done and dusted, it's gone. No, it's not that. Part of the process, you have the right to defend yourself. Okay, so that is the the principles of natural justice that basically defines what a procedural fairness letter is. Okay, now, a quick observation here. I read and see a lot on the internet where people are saying that the procedural fairness letters have really gone up substantially in 2025. Now, I have been working with this for a very long time and predominantly focusing on various shapes and forms of procedural fairness letter for a reasonably good period of time. From my experience, I don't really see that 2025 has resulted in an increasingly higher number of procedural fairness letter of any sort, right? The only observation that I have is that the shapes of procedural fairness letter, the terminologies that the officers are using in those procedural fairness letter have changed. So I think a lot of the consultants and the lawyer are seeing these in the recent past because of their nature of practice. But because we deal with this, we have been dealing with this for a fairly long period of time, I could confirm that I don't really think personally that the number of procedural fairness letters have gone up or that the officers have become extra strict and whatnot. It's the routine process. It has always been the routine process, but the terminologies of some of the procedural fairness letters have most certainly changed. For example, one of the recent cases that I've dealt with, the officer clearly mentioned that if you have to hire a representative, it's your job to compensate that representative. So you cannot say that I sort of dealt it on my own and therefore forgive me. No, the officer was absolutely specific. The another one, like literally, I have seen this quite a few days back, and where the officer said that you should hire a representative to deal with this. So this is something that is, to me, this is very, very new. Okay, so the terminologies have changed in this, in the procedural fairness letter, but I don't really think that the number of procedural fairness letters have gone up or anything of that nature, right? So, what are the most common forms or the common sections that one finds in a procedural fairness letter? Okay, the most common section that one would find in a procedural fairness letter are section 16 of the Immigration Refugee Protection Regulations and section 40. Okay, now these two sections are sort of interconnected, and I will explain that in a second. But basically, fundamentally, what section 16 does is that section 16 says that if you are a foreign national and you were applying for any kind of visa, etc., etc., it's your job to be truthful in your submission. Second part is important for the purpose of examination. Okay, now if I literally have to read from the law, it says that a person who makes an application must answer truthfully all the questions put to them for the purpose of examination, and must produce a visa and all the relevant evidence. The most important term is that answering all the questions truthfully for the purpose of examination. Okay, and therefore the background declaration forms comes into picture. The statutory declaration forms come into picture. Okay, so you cannot really say that I forgot to mention my US visa refusals, or I forgot to mention the arrested seat, etc., etc., because it's your job to answer all the questions truthfully. Now, people make mistakes, and there are exceptions to that. But generally speaking, the expectation from you, the client or the applicant, is that you must answer all the questions truthfully for the purpose of examination. So, what is an examination? This is where I see a lot of doubt. So, in Canada, there are different kinds of examination that one must have to undergo, right? PCC, you produce a police clearance certificate. Why do you do that? To clear your criminal examination. You sometimes you have to go through a medical examination. Why do you do that? To ensure that your presence in Canada will not cause any excessive demand on public health. Okay, so these are the various different kinds of examinations, and you also have to show something called a proof of fund, right? Why do you do that? To pass on financial examination. So Section 16 basically says that the officer's right is to carry on the examinations, and the officer would require you to answer various questions. The officer would require you to produce various documents such as a PCC medical report, etc., and it's your job to ensure that you're answering everything truthfully and you're producing all the correct documents. If either of these things are in question, let's say if you do not declare a past visa refusal, or you produce a fraudulent document, etc., etc., or you do not tell what you should tell. Okay, now this is also important. Then there comes Section 40. Some of the officers leave it at Section 16. Some of the officers do not even mention any section. That's a different story. But many of the officers leave it at Section 16. Some of the officers include Section 40 as well. So Section 40 is, at least in my opinion, is a little bit serious one. Section 40 basically says, and now again, if I have to read through the law, that a permanent resident or a foreign national is inadmissible for misrepresentation, for directly or indirectly. Now, this is important: directly or indirectly misrepresenting or withholding material facts. Again, this is important: either misrepresenting or withholding material facts relevant to the matter that could induce an error in the administration of the act. So sometimes people think that if you're producing a fraudulent document, let's say a fraudulent bank statement or a marriage certificate, etc., only that amounts to misrepresentation. But the law says that it is both. It's either or. Okay, producing fraudulent documents or withholding some information, not telling them the truth. So, for example, you were married previously and you're not saying that you were married, okay? That is withholding material information. You are producing a fake IELTS report or a fake marriage certificate, fake bank statement. Those are producing incorrect information, or as the law says, misrepresenting information. So it could be either withholding or producing something that is not true, could tantamount to misrepresentation, which means that you'll be inadmissible from Canada for a period of 5 years under Section 14. Now that is quite serious. If somebody is being made inadmissible, it's very difficult. It's really, really very difficult to do anything within the period of the inadmissibility. So that is serious to me, at least, and one should take it very, very seriously. And now, as you see, Section 16 and Section 40 are pretty much interconnected, because if you're not answering anything truthfully, which means that either you are withholding a material fact or maybe you're misrepresenting something. So some officers, again, just leave it at Section 16. They do not talk about Section 40. But many of the times they talk about Section 40, which means that you have to defend both Section 16 and both Section 40. So whatever sections that you see are being put forward in the procedural fairness letter, those specific sections need to be countered on legally with submission. That's the whole objective of them giving you either 7 days or 15 days or 30 days of time, right? So that is basically what is Section 16 and Section 40. Withholding, as we have discussed, not declaring something which you should have declared. Misrepresentation, as you know, right? Not telling them the truth, okay, or producing something that is fake IELTS report, marriage certificate, etc., etc. Either or both could tantamount to misrepresentation. Now, some people genuinely make mistakes. Okay, so for example, it's a permanent residency application, and it's logically does not really make sense for you to not to talk about your past US visa refusals or any visa refusals for that matter, because by law, a routine temporary visa refusals would have no impact on a potential permanent residency application, right? So those kind of mistakes, if the officer calls it a misrepresentation or withholding of material facts, could potentially be termed into innocent mistake or an innocent misrepresentation, and therefore one should potentially seek an exemption under the innocent mistake exception category. Now, if that applies to you, okay. Now, there are numerous precedents in the law. There are numerous case studies that substantiates the concept of innocent mistake. So, if that is something that is relevant for somebody, the person should sort of counter that. Okay. Other question that I get in the whole scheme of PFL is that does receiving a PFL mean that you'll be banned or that your visa will be refused? Okay, or it will be both. Now, not really. Okay, we as an organization we have been dealing with procedural fairness letter for a substantial period of time. This is our bread and butter. We deal this every single day, and our success rate still stood at about 98, 99%. Now, some of the cases we just don't take, but the cases that we take, majority of them result in successes, and that tell me that if it is not for a fraudulent document, okay, now that's something we don't deal with. If you produced a fraudulent document, no matter whatever you do, you will unfortunately face a ban. But other than that, if it's a genuine case and you have logical reasons behind it, and if those reasonings are being put forward in the context of immigration law and the immigration regulations, one should generally be fine. That's what my experience tells me. So receiving a procedural fairness letter really does not mean that you'll be getting a ban or this application will be refused. It just means that the officer has a concern that you have to counter. That countering that I will talk in the subsequent section of this session, but the countering that is very, very important. If not countered correctly, the officer reserves the right to proceed with the decision based on what she thinks is the best. Okay, let's talk about various examples of of procedural fairness letter. The most common one, production of fraudulent document. Now, disclaimer: we don't take cases of that nature. Okay. Because if you produced a fraudulent document, it could be any fraudulent document, you will potentially get an inadmissibility or a ban, and then there is no point in taking, paying money for that to somebody who would not be able to help you in any ways, right? That's the example. That's an example of a procedural, like an example of a procedural fairness letter where the ICC says that you have produced a fraudulent document and therefore ICC thinks that you should be held for misrepresentation. Non-declaration of the previous visa refusals, very, very common. It's your job to ensure all the past visa refusals you declare in your application under the statutory declaration sections. If you forget to do that, you will be receiving a procedural fairness letter. Non-declaration of previous marriage. I have seen a lot of cases. One got married to somebody, did not work out, got divorced, but that marriage is not coming into the subsequent application. You never mentioned this. Okay, so that's important. Okay, and sometimes also the separation is going on. The formal divorce is not being signed, but the person is writing as divorced without being able to produce a divorce certificate. That's a misrepresentation. Very common procedural fairness letter. Another is the failing to declare spouse while one receives the the permanent residence. Now, this is something like you got your PR is in process, you flew home, got married, and there, while getting married or just before marriage, you got the confirmation of permanent residency in your mail, or a visa has been stamped for you, right? And you thought that, well, my PR is being done. You come back, but then you got married already. You come back at the port of entry, and then you declare yourself as single because your co-PR mentions yourself as single. It's been signed. And then when you're trying to launch a spousal sponsorship or a family class application to sponsor your spouse, The IRCC says that, well, you should have declared her for the purpose of examination, and therefore she will now not be considered as a member of the family. That's very, very common. Be careful with it. Failing to understand how common law aspect works. Okay. Living together for 1 year consecutively generally tantamounts to common law, provided all the other legalities are met. But ILCC, and particularly Case Processing Center in Niagara Falls and Mississauga, sometimes Etobicoke as well, have a tendency to just see the dates you have been residing with your significant others or your girlfriend, and then they consider that as a common law relationship. So if you guys are in a common law relationship, declared it as common law. Doesn't matter which custom or whatever legal, like a like traditions you guys are coming from. It's Canada, and Canada recognizes common law. So declare it as common law. Non-declaration could potentially lead to a procedural fairness letter. Marriage of convenience. Now, this is significant. Having a big fat wedding does not really mean that the marriage will be considered as legal or something that is not made out of convenience. If the intent behind the marriage is not being presented or portrayed correctly, that marriage is has the potential to be considered as something like a marriage of convenience and a procedural fairness letter to be issued. So, marriage of convenience, IRCC not thinking that it's a genuine marriage is a very serious kind of a procedural fairness letter, and one should be dealing with them very, very seriously. Fake invitation letters to obtain a TRV. And now at this point, I think I can write a book on the examples of PFL because there are so many. But fake invitation letters. You don't know somebody, but somebody told you that if you get an invitation letter from me, there is a high chance, if not 100%, your visa will be approved. You do not really need an invitation letter, first of all, to apply for a visa to Canada. You may not know anybody. You could just visit. You can literally go to Banff and Niagara Falls, like seriously, and not for the purpose of writing those in the purpose, in the letter of explanation. But faking invitation letters tantamounts to really, really ban. If you do not know somebody, don't take the invitation letter from that person. You will face a ban. The person should still be fine, but you will face a ban. Be careful about it. Failing to declare previous criminality or arrest warrants. Okay, it's your job to declare all the previous criminality, arrest warrant, removal order, etc., in your application. Failing to do that will result in a PFL. Lack of substantiated proofs to prove your relationship in your family class application or even in open work permit application for the spouse. So obviously, family class application or a spousal sponsorship application being a PR application carries on higher burden of proof to prove that your relationship is genuine. Okay. But even in open work permit applications for the spouse, the IRCC is issuing increasing number of procedural fairness letters where the relationship is not being proven correctly. Producing only a marriage certificate in these days really does not prove much. Prove the relationship, otherwise you will face a procedural fairness letter kind of a situation. Medical inadmissibility for super visa situations. Very, very, very serious ones. I have said it numerous times in my video, and I'm going to reiterate it this time as well. If your parents have any kind of a medical problem, if you think they have, or that could potentially result into any kind of a problem, have them checked properly. Okay, have them checked properly before lodging the super visa application. Because if the IRCC, particularly IRCC Niagara Falls, is issuing you a procedural fairness letter stating that your parents' presence will cause an excessive demand on public health, if whatever the outcome of that application is, I could tell you that decision will linger on for years, months. Okay, the decision making process is very, very, very slow for medical inadmissibility related cases, and therefore this is something that one should avoid. But this is a very common examples of a medical inadmissibility PFL. Another very common example, dissimilar work experiences between the temporary residence as well as permanent residency applications. If you have declared a temporary residency, declared a work experience in your temporary residency application, it should be declared in your permanent residency application and vice versa. Okay. If not, explain proactively. The common occurrence is that people do not declare a lot of the experiences in their temporary residence application, such as a study permit or a work permit application. But when they're lodging the PR application, because of the advantage of getting the additional points, they're now declaring everything. But that experience was not declared in the previous time, right? grounds for a PFL at a serious one of that nature, potential for application refusal, be careful about it. Working with unlicensed representatives. Now, this is something, there are a lot of videos on internet, but one should be careful if you're working with somebody who is not licensed by CICC or who is not a lawyer with good standing in any of the provincial law societies. You are being part of an illegal act. I have no other ways to say this. So do not work with unlicensed representatives, because working with them, if ICC finds out, they have no authority to have your application submitted on your behalf. Okay, so their involvement would potentially lead to a serious kind of a procedural fairness letter and potentially inadmissibility. Be careful about it. Using someone else's credit card to make the payment. If you're doing so, make a declaration. If not being done, a very serious PFL and potential for ban. So be very careful about it. Okay. So these are some of the examples of procedural fairness letters, right? Obviously not everything, because that's like, I have seen at least I don't know how many different variations of procedure, but these are some of the most common ones that one should know of. Other question that I get is that, can I really withdraw my application after receiving a procedural fairness letter? Short answer, no. You can definitely place a request for withdrawal after you have received a procedural fairness letter, but 99.9% of the times you will not get a response, and your application will be, a decision will be made on that application based on whatever information the officer has on file, which may either result in a ban or a refusal or both. Because if you are trying to withdraw that application, if you're making a withdrawal request, you're essentially not responding to the procedural fairness letter. And the procedural fairness letter clearly says that if you decide not to respond to the procedural fairness letter, the officer will make a decision based on the information has on file, which could result in either inadmissibility or refusal or both, right? So when a procedural fairness letter is being issued, your application is then being considered as an active review stage. The Government of Canada professional services fees, their service fees that you have paid, have already been utilized. Withdrawal means they have to refund you the processing fees, but your application is already in the active review stage. An officer has some genuine concern, so they cannot just let you withdraw that application. Okay, so making the request is even quite dangerous at that time. A lot of people do it, but do not really do it. Another question is that, can I request for a deadline extension? Now, this is very common when somebody speaks to a lawyer and the lawyer says that, I'm going to do a Rule 9 request or whatnot, apply for the GCMS notes, I'll ask for another 30 days of deadline extension, and then we can respond. Depends on how the person is reviewing the situation. In my experience, in my professional sphere, in these many years, I have requested for deadline extension only one time in my life. And that one time that I made was when the response time, the person received a procedural fairness letter on 24th of December. And I'm not sure why the officer has given time only till 31st of, I think 30th of, 31st of, 31st of December for a response. So that's not the time that I was working. The client approached me on the 24th itself, took an urgent consultation. I told the client, I'm not working in this time. If you want me to be involved, I would have to request for another week's of deadline extension. Okay. That's the only situation. But other than that, I have never requested for a deadline extension. And as I have said, the success rate that I still have is about 99%. When the officer is giving you 7 days, 10 days, 15, 14 days, and 30 days of time, the officer is allotting the time frame based on the authority that she has. Okay. And 99.99% of the times, if not 100%, one should be able to respond to the PFL within that time. If the officer is issuing you a procedural fairness letter saying that you have failed to declare your previous US visa refusals, explain why, you really do not need 30 days for that. It is 7 days, 3 days, 4 days, more than enough, even to do legal research. Okay, if the officer is giving you 30 days to respond to a procedural fairness letter for any kind of a permanent residency application, 30 days is more than enough for you to do anything. The only time that officer gives you more time than 30 days is for the medical admissibility related cases, when the officer is sort of asking you to carry out additional tests. Those take time. Other than that, no, you really do not need to go for a deadline extension. Um, you should be fine. Otherwise, if you're doing it by yourself, if you know how to do it, but if you're working with somebody that knows how to do it, there is no question about deadline extension. The other aspect then comes how to respond to a procedural fitness letter. And in that section, I will talk about a couple of mistakes that you should not make. Okay, if you decide to respond to the procedural fairness letter all by yourself. Now, this is something, well, as a process, we do not really talk about our services, etc., during any of this. But this is something you have to understand. If you have heard the term procedural fairness letter for the first time, it's quite likely that you will probably not be able to respond to the letter properly legally. If you do not know how a Canadian legal standard, legal writing standard work, if you do not know what a citation is, if you do not know how to make sense of the relevant case laws, it is likely that you will not be able to respond it. But it's really up to you whether you decide to hire a representative or to do it by yourself. But regardless, take your time. If the officer is giving you 7 days, you have 7 days. If she's giving you 30 days, you have 30 days. I see a lot of times where people, just responded in a haste, like literally 3, 4 lines. And then they come to me said that, well, I watched your video after response. Could you please resubmit the response? Happens a lot. Take your time, take a deep breath, research a little bit. You do not really need to panic because you have some time, and respond accordingly. But at the same time, just do not wait till the last day. If they've given you 30 days of time, you have no reason to wait till 29th day. Make a reasonable effort to do it on a reasonable period of time. Doing so shows your urgency, and also the officer is then able to make a decision sooner, which would give you much needed mental respite, right? Second important thing you to understand, it's a legal response and probably a professional help is warranted. And as I have said, that IRCC started mentioning in their recent letters that if you have to hire somebody to do this work, it's your job to pay their fees. Okay, so again, understand, if you can do it, if you can do it, if you think you can do it, go for it. If you're not, hire a representative from day one rather than when it is the last moment, or rather than when you have already responded to. It will be too late for you for the most for the most time. Other thing you have to understand, that procedural fairness letter response is not really an emotional story. Okay, and you have to answer the question. As like during my practice, I have had quite a few calls with the actual reviewing officers because they had some questions and they called me to get clarifications. It's your job to answer the questions, and that's the feedback that we have received from all the officers all the time. It's not your emotional story. If the officer is saying, why have you produced a fake bank statement? You cannot just continue to say that you have been a doctor all your life and that you're doing so well, you're contributing to your community, etc., etc. Immaterial. The question is why a fake bank statement is being produced. That's the concern. Answer to the question. Okay, be specific. Another thing is that you have to counter all the legal sections that we put forward in your PFL. If the officer is asking about section 11, is talking about section 11, counter that with your defense. Section 16, same thing. 40, same thing. 87, same thing. Whatever legal sections that the officer mentioned, it's your job to ensure that you are able to counter all those sections legally with case laws, etc., etc. A procedural fairness letter response is not like a one pager or a couple of paragraphs kind of a response. It's a detailed one with citation, with annexure. So be careful on that front. Okay. Case laws are important, like citations, precedents are extremely important if you find any relevant ones. Now, there are legal research that needs to be performed to do that. So if you're, working with a professional, I'm sure the person would do it for you. But this is important for you to ensure that some relevant case laws are being mentioned, not being too aggressive on the officer, but being able to ensure that you're being able to defend yourself. That's very, very important. Seek relevant exemptions or exceptions in your response, such as innocent mistake exceptions or humanitarian compassionate grounds exceptions, if those exceptions apply to you. Okay, now Last thing is that submit a comprehensive response. Again, as I have reiterated quite a few times, it's not going to be a one pager or a couple of paragraphs kind of a response. If you talk about now, again, my practice, the typical procedural fairness letter response that goes on my legal letterhead has a submission length of typically between 10 to 15 pages. With annexures, it sometimes become 20, 30, 40, 50, 60, 70 pages. The recent example that I have, like I've submitted the file as latest as Friday on a spousal PFL about a 43 pager, okay, because they're asking for a lot of photographs, etc. But you have to explain. That brings me to another point, that if an officer is giving you a procedural fairness letter, you have to explain. If they're even asking for some documents, you just don't upload those documents and thank you very much. You have to explain your situation, stance, etc., and then have them annexed like the way it should be annexed. Okay, so this is something that one must need to be careful. What really not to be done in your procedural fairness letter? Now, I'll talk about a couple of points. Those are absolutely no, and you should be very careful about it. Now, passing on the blame to somebody else. I did not do it. My representative has done it, who is not licensed. First of all, you should not be working with a licensed representative, unlicensed representative. So if you tell IRCC that you somebody local from India or any other country had done it for you, that itself tantamounts to misrepresentation, because that representative was not able to declare himself or herself as a representative on file, and therefore that is like withholding material information under section 40. Be careful about it. So do not pass on the blame to somebody else. It will not work. Even if you're working with the licensed representative, you still cannot pass on the blame to the licensed representative, because it's your job. The law is very, very clear. IRCC is very, very clear that you should be able to review everything by yourself before the representative press the submit button. So no excuse that representative did not share this with me, that with me. It's your job to do it, to ensure that he or she shares with it. We as an organization, we share everything with our client. The client approves it. We take those feedback, change it. The client approves it. We get the approval on email before we submit the response. Okay, so be careful with that. Do not pass on the blame to somebody else. That will not help you. Be overly emotional in the procedural fairness letter. It's a legal response. I understand if you're doing it by yourself, it may come up to be like shocking for you, but you have to think it from their perspective. To them, it's just yet another application. You have to be factual, legal, practical, comprehensive. Being too emotional will probably not help you. Another thing is that a kind of a statement that, well, I have handled it all by myself and therefore I am sorry, I did not know it. Now, not knowing something is not an excuse in law. If you did not know something, it's your job to know it before you do it. This is how IRCC and the law enforce, right? So if you have not hired a representative, you have taken a conscious decision to do it. If you have not reviewed the files being submitted by your representative, again, it's your action and therefore IRCC would blame you. All these kind of things will not work. If you're working with a licensed representative, it's your job to review the representative submission letter. Now, this is very strange that 99% of the times clients tell me the representative is not sharing the representative submission letter. Beyond me, because why? It's not his or her letter, it's your letter. You paid for it. So if the representative is not sharing the letter with you, ask him, request him or her, get access to that feedback and ensure that you know what the final version is being submitted, because not knowing that would lead you to the problem, not to the representative. So be very, very careful with it. That brings me to the second, the other aspect is that, can I hire a representative after receiving a procedural fairness letter? The short answer is absolutely yes. Okay, it is not going to be having a negative impact on your application. If the representative is good, I'm assuming that it will have a positive impact on that application. Again, over 90% of the clients that come to me, they come to me when they were handling the application by himself or herself, or they have been working with a representative already who is either not helpful or not very proficient in a procedural fairness letter response, and they come to me. It's not a problem. We take those case over. 5 minutes process to change representative. IRCC is very, very supportive of it. If you're raising a web form, it just comes fine. Okay. Another thing, as I have already explained, can you change representative while after receiving a procedural fairness letter? Absolutely, yes. No negative impact on that application. Again, if the representative is good, hopefully the impact will be positive. Okay. So even if again the response is being submitted by the representative, the onus lies on you to review it to ensure you know what's been going on in there, and so that you're clear. It's your file, it's your life. Nobody knows it better than the representative, right? So representative can write the letter, but it's your 100% responsibility to review the letter to ensure you know what's been going on there, the facts that's been submitted in the letter, and to ensure it's watertight. Okay. So what really you can do after a response to the procedural fairness letter has been submitted? It's a very common question. What are the next steps? If the procedural fairness letter response has been submitted correctly and you have received the submission confirmation, regardless of where through like a web form or through the portal, it really does not matter. If the response is being submitted correctly, the only thing you can do is to wait. Really, nothing else. You do not have to do anything unless and until ISS is asking you to do anything. Some decisions take time, weeks, days, months, years. I have seen it all. The only request that I made to my clients is to wait, and my clients are amazing. They all listen to me. If being impatient, raising multiple web forms will not help you, have never helped anybody. Do not think that your file is in is not being processed and etc. I know some applications take time. For example, outside Canada, family class applications, and when you the spouse was not declared for examinations, those decisions take years, I could tell you. Okay. Though the sponsorship application from India, the family class application from India, let's say for example, this is just India is just an example, right? India gets processed within 4 months. If you have received a PFL on a family class application, that will drag it for over 1 year. Easily, I have clients who have been waiting since last summer, yet no decisions. And ISS is working on the file. I've applied for the GCMS notes. I know that ISS is working on the file. So some applications take time. So patience is the key here. And I know easier said than done, but because I see a lot of unfortunate situations being on the other side of the table, it's my job to tell you. Other thing that I actually missed touching on before, can you submit a procedural fairness letter response after the deadline is passed? So ideally one should not, because it's your obviously it's your job and the job of the representative, if there is a representative involved, that you should submit everything on time, before time rather, but you still have some leeway if it's not way too late. I have numerous examples where you know I have submitted because the client approached me after receiving after the deadline is over, and then we saw some exceptions and we submitted that it and it was really fine. Can you resubmit the procedural fairness letter response? Very common. Sometimes people respond to that in a haste and then they find some videos, they realize it's a little bit more serious, and then they come to me, consultations, etc. So I have also resubmitted the response in numerous times. You have to understand it's really the discretion of the IRCC whether they would consider that response or not. In my experience so far, about 80-85% of the times they have considered those responses, but I cannot assure you that they will continue to consider the responses once the formal response has already been submitted. So the ball is now on ISS's score to sort of consider, not a very ideal situation. Other thing is that can you receive an interview call after a procedural fairness letter response has been submitted? Okay, 100% yes. I don't know why people are talking too much about it. The law, again, I'm reading section 16 here. Section 16 clearly says that you have an obligation to appear for an interview if the officer requires you to come for an interview to carry out an examination. You can read, just literally, it's available online. Section 16 of the Immigration Refugee Protection Act of Canada, that gives an officer to write for an interview if the officer is not satisfied with your with your submission, with your thing. Yes, you can appear, you may be called upon for an interview, but those things in my experience are more common for unsubstantiated or lack of comprehensiveness in the response, particularly for the family class application. That's when the officer calls The husband and the wife ask the same question, tries to get a parity. Okay, happens a lot in case of work permit applications, where the officer thinks that the person is just trying to come to Canada and the job offer is not genuine, etc. Calls the employer, calls the calls the candidate. Happened a lot. Ask the same question. They find the disparity. Therefore, the thing is, prepare your application well, answer honestly, and you should be fine. From my experience, interview calls are almost non-existent. I have received quite a few calls from my NCC because the officer needs some clarification, and it's a routine process. They call the representatives to get clarifications, no problem. Interview calls, only one example I have where my client received an interview call because her marriage certificate and it was procured somewhere from Africa was not really clear. So she was called upon like a physical. So basically, she was asked to present the physical copy of the marriage certificate for verification. Okay, happened perfectly all right. 5 minutes process. Okay, so interview calls not very common, at least in my practice. Generally, I see it's happening, but the law clearly has a provision to it. The officer really reserves the right to call you for an interview as a part of the routine verification if there is a problem, if there is a serious problem, because you see, carrying out an interview is even a time taking exercise for the officer. The officer also wants to wrap up the process in a reasonably quicker time, right? They don't really want to linger on to the process for a very long period of time, and therefore it's not really a preferred way to do it, but they have to do it when they think there is no such other option, and therefore answer well. If you received a procedural fairness letter, please ensure to answer well. Answering well is the key here. Be comprehensive, be open-ended in terms of answering further questions, but be close-ended enough to close all the arguments from your side. That's very, very important. Lastly, is the procedural fairness letter success rate. Now, I cannot talk about anybody else, about the industry, because I don't have access to any of those such data. I can talk about mine. The procedural fairness letter success rate with Nuvonation remains still at 98, 99%. Of course, not all successful. And as I have said, big disclaimer, to ensure that our high success rate is being maintained all the time. I do not take cases of the fraudulent document, etc., because I know whatever I write, ISS is going to ban the clients anyways. There is no point in taking money and not being able to help. But other than that, the cases that we handle, the success rate remains still at 98, 99%. All is not successful, all will never be successful, but at least that high success rate is still being maintained. That's pretty much about it today. I hope I've been able to cover almost everything about PFL. We as an organization, we specialize about this topic. If you need our assistance with any of the aspects of procedural fairness letter, inadmissibility, misrepresentation, anything of that nature, more than welcome to hop into the website www.nuvonation.ca. I'll be happy to have a case specific discussion with you and answer all your questions. Hope this helps. Have a good Father's Day. Have a good Sunday, rest of the day. Bye now.